the person shoots the deer to end its suffering, the person drives away without contacting authorities, has that person committed a crime?
Well, there are a
Like
lot of.
anytime you discharge your gun, you better believe the government has something to say about it. We are the armed attorneys. Today we got some tough gun law questions from you, the viewer. We get these when you leave them in the comment section below. It helps if you type the word out question in it so we can find those things really fast. So we got some really good questions. Going to be talking about some post office conundrums, some castle doctrine conundrums, the downside to giving a verbal warning, and these folks that ban firearms on private premises, why haven't they got sued when things go haywire? But before we begin, show your support for the Second Amendment by hitting that like button. And today's video is sponsored by Aura. Hey, you want to see something crazy? I just googled Edwin Walker. Is your address
What? How did you know that?
in your phone number? It's also listed here. I know it, but it's 7.
Where are you getting this? I try to keep that information absolutely secret from everybody.
It's scary how easy it is to Google someone and find out their private information: home address, phone number, email, and more. These sites are run by data brokers who collect your information, package it, and sell it to anyone. Marketers, scammers, identity thieves, all without your consent. They're legally required to take your data down if you ask, but they bury you in the process in legalese and in endless forms, hoping that you'll give up. Or you can do what we do: use Aura. Aura finds these data brokers, submits opt-out requests on your behalf, and keeps working in the background to keep you protected. After a few weeks, you'll stop seeing your information on these sketchy sites. Aura also monitors the dark web for your email, phone number, and even social security number. If someone tries to use your information to get into your bank or credit accounts, Aura will alert you fast. And if the worst happens, Aura has your back with up to $5 million of identity theft insurance with their 24/7 US-based fraud team to help. It also comes with top-tier VPN, password manager, malware protection, internet parental controls, and real-time credit monitoring. Aura protects your identity, money, and peace of mind. Go to aura.com/armedattorneys to try a 14-day trial for free. That's enough time for Aura to start scrubbing your personal information from all those data broker sites automatically. So, Edwin Walker, thank you for joining us on the questions. I think we got some good ones here. Do you want to kick us off?
Yeah, the first one comes from at Carl Leth. And his question is, if you issue a verbal warning before using lethal force in self-defense, could a prosecutor argue that if you had time to warn the subject, it was therefore not an imminent threat?
No, I mean, it's a good question. And this kind of tracks the logic in what we say about warning shots, because what is a warning shot? Well, it's a use of lethal force, deadly force, but at the same time, you're saying it's not immediately necessary because I had time to calculate, point in a safe direction, and discharge. So you're kind of handing a conviction with maybe not great self-defense facts over to a prosecutor. Now, does that hold true with giving somebody a verbal warning before actually, discharging your firearm? Because, I mean, you hear that, and I see it in the gun forums. If you're going to pull that gun, you better use it, right? Or, I mean, that's the kind of stuff that you see. So I can see a situation where giving somebody a warning, if it stops the threat, I'll say using the least amount of force necessary. That's very good self-defense principles. But these situations are dynamic. If the person turns their attention to you and then, attacks you, right? And you have to defend yourself, is that really going to be held against you? I can't see that same argument holding up that we have with warning shots because, look, the necessity isn't the necessity at the time of the warning. The necessity is at the time that you're getting violently attacked.
Sure. And keep in mind that, two things can be true at the same time. So just because you gave them a warning doesn't mean that the threat wasn't imminent.
Right.
Both of those things can be true. And, obviously, if you have given a warning and then had to been, forced to use deadly force afterward, it is possible that can actually embolden your claim. It's like, look, I went to the less lethal option first, immediately had to follow that up because the person did not break off their attack. So, that's sort of the art of litigation, is that the criminal defense lawyers say, look, it's a great thing that he gave him a warning. Prosecutor, they always will try to smear somebody with anything they can. And so, sure, they'll say, not only did he give the warning, but he also had some very bad bumper stickers that we're going to talk about a little later.
Yeah. All right. Next one. This one, I'll give this one to you, Edwin. This is from Jeff Broders 971. Question difficulty level 10.
Oh,
I'm not even,
wow.
not even the postmaster has been able to answer. If it is legal to ship certain firearms through USPS, but illegal to take firearm into the post office, which is correct? These laws are counter to each other.
The old conundrum. If I'm allowed to mail a gun, how do I get the gun into the post office to mail it if I'm prohibited from taking the gun? I think your postmaster knows the answer to this. He just doesn't want to tell you because he's a government official, and government officials will never go out on a limb or be perceived as going out on a limb to give somebody accurate information. So your postmaster probably does know the answer. The answer, in my opinion, lies in the actual prohibition, which can be found at 18 USC 930. That is the part of the law that says you cannot take a firearm into a federal facility. Well, there is a provision of that law. I don't know I think it may be subsection C, subsection 3, which says that you can take a firearm if you're in lawful possession of the firearm. You can take a firearm into a federal facility if it is for a lawful purpose.
I was going to say the lawful purposes.
And since obviously you are allowed to mail a gun, in which we shouldn't say a gun, you're allowed to mail a long gun, or a shotgun. You cannot mail a handgun through the U.S. Postal Service. You got to find some other alternative for that. So you bundle up it always has to be unloaded. So you make sure it's unloaded. It's already packed. Don't go to the post office thinking you'll get a box there to pack it in. Unload it, pack it yourself. You have to declare it when you bring it in. You go, hey, I got a gun. So don't label it that it's a gun, though. You can't label it. You have to physically tell them. And so you're actually engaging in a lawful purpose that's authorized by the postal regulations. You've complied with them, and so you won't get in trouble for that.
Yeah, don't walk in unboxed, holding it, screaming, get on the ground and hand me that box so I can box this up. They don't like that.
They won't react positive to that. Our next question comes from Dave Callister, 8251. 8251. I wonder if his birthday happens to be August the 2nd, 1951.
Possible.
Yes. Question. I'm out of Nevada, but I don't think it makes much difference for this. You have a concealed weapons permit. You change address in the same county, update your driver's license, notify the sheriff, but don't get a new CCW card. When buying a firearm, what will that affect the 4473 as the address on the CCW and the DL are different?
Yeah, FFLs do not like that.
No.
They want they want all the documents to match. So it's very, very important. And so what does this mean? Well, you'll be able to engage in the purchase of a firearm using your driver's license only is what I would probably recommend. And you won't be using your CCW as a substitute to the NICS background check. So you're going to fill out your 4473. You're not going to have some substitute for the NICS background check. So they're going to phone you into the FBI to make sure everything's all on the up and up, and then, finish the transaction, assuming that there isn't any kind of like delay or deny. Now, if you go in with two documents that don't match, what you can expect is the FFL to refuse to give you service.
Right. And also keep in mind, this is a very good opportunity to remind people, check your state's laws, because a lot of states require that all of your government IDs have the same information on them. There's a law here in Texas that says that the address on your LTC has to match the address on your DL. Obviously, this was much more important back in the day whenever there was not permitless carry.
Yep.
But under the law, they still have to match. So when you're changing your ID, and since usually it's the same agency that issues them, it'll be no problem to change those both at the same time.
Yep. All right. Next one we have is DN88S question. If my tarp or tent I'm sleeping in is my castle, does someone literally have to be inside my tent for the castle doctrine to apply? I'm going to say short answer is no, but it's going to depend on how your state's law is written, because here's what it comes down to. Most states invoke castle doctrine protections inside of your habitation when someone has entered, all right, so we don't have that in your hypothetical, or someone is attempting to forcefully and unlawfully enter. So what does that look like on a tent? maybe it's grabbing a zipper and undoing it, or maybe it's slashing a knife through the side of it. I don't know. I mean, I can imagine 1,000 different scenarios, but do they have to physically be in the tent before Casa Doctrine is invoked? It's going to depend on your state's law, but probably not if you have that provision that says attempted forceful and unlawful entry, that triggers Casa Doctrine. You might have that protection.
Yeah, and that's all going to come down to what your perception was. Was your perception, what did you perceive? Was it reasonable? And would it be interpreted by ultimately the jury as, yes, that's exactly what somebody would do if they were attempting to unlawfully enter this habitation?
Yeah.
So yeah, we've all seen the horror movies where you see the murderers. Am I allowed to say that on the YouTube?
Yeah, they don't care about that one.
Okay. The murderer's silhouette on the tent.
If anybody's
outside.
wondering what just happened, YouTube is censoring us so bad. So we have to real time, are these words on the naughty or nice list? So that's what that was. Sorry.
Yes. So, I watch movie reviews of slasher films all the time.
Yeah, that's all fine.
Yeah, are those people not getting...
They don't get the special, you're a 2A content, creator, so you don't get that.
Okay.
Special treatment.
So you see the silhouette outside the tent holding the axe. Would a reasonable person believe that your perception was that that person was attempting to make an unlawful and forceful entry into your habitation?
Yeah, I think so.
Alrighty. Our next question comes from Tree Armament. And Tree Armament has a very interesting question. I know we talk mostly on this channel about criminal prohibitions of relating to firearms and self-defense issues. This has to do with what happens civilly. So his question is, why has there not been a lawsuit for damages or negligence against a location that has denied firearms and someone is shot or killed when they were denied the right to have protection? And, this is a question that we have considered speaking to folks for 15 years now.
Yeah, and I'll say, the short answer is, there isn't a common law cause of action for that specific circumstance. So we have to look at the conditions, and most of the time this is going to be negligence, gross negligence, for somebody who has a property. But we've seen a few states try to introduce laws that would create like presumptions of negligence or gross negligence for excluding firearms, and then there's some kind of incident there. We saw that in Tennessee. Texas, we had a similar proposal. It didn't really get anywhere, but ultimately it comes down to, to claim negligence for, a property owner who's inviting people to come and do business on their property. There has to be a duty. Well, we got that duty from hey, look, you're invitees on my property. Breach, they fell below the standard of care of what an ordinary and prudent, hey, property owner would have done. Damages happened. This person suffered injury. And then there has to be this kind of causal nexus between the breach and the cause of those damages. And so I can tell you, there's not really any court precedent on this because they don't go that far. That nexus of damages between criminal actors criminals can do all kinds of crazy things all the time, shifting that burden over to property owners to know when crime is going to occur. We just haven't seen the right facts to get an answer to that question yet. Next question is for GW641 or GW641. We'll see. Tell us how you think you pronounce this in the comments. This is to you, Edwin. Question. Theoretically speaking, a person with a legal firearm, in this case a pistol and a CCW permit recognized by the state of Colorado, is driving in that state on a rural road and sees a deer that has been hit by a car but is still alive. The person shoots the deer to end its suffering. The person drives away without contacting authorities. Has that person committed a crime?
Well, there are a lot
anytime you discharge your gun, you better believe the government has something to say about it.
Right, but there's a lot of elements in here that, since this is a hypothetical.
Yeah.
Number one, how did you know the deer was hurt? Was it laying in the middle of the road? I mean, how did you know that it was still alive after the injury? Number two,
there's that scene from Me, Myself, and Irene with the cow. You ever seen that? I'll show it to you later.
Okay. Number two, you're on a rural road. Who's going to know? Number three, yes, nobody likes to see animals suffer. It's a horrible thing to observe, but is it something that you want to risk your, risk your freedom to alleviate? And if you do it, jump back in your car. You've already said that it's a rural road, nobody around. You drive away. What have they got? A forensic team that's going to examine this and figure it out? As a practical matter, though, I have actually fielded a call from an individual who was in a very similar situation. They were on a roadway. I don't know if they happened to hit the deer or that the car in front of them happened to hit the deer, but it was a similar situation. And what they did was they called the sheriff's department. The sheriff's department sent a deputy out there, and the deputy did the deed.
Yeah, or you'll see a lot of times like calling your wildlife department. Texas Parks and Wildlife is our here, sending out a game warden to handle it. We just added, for example, a defense to our discharge. It was discharging across a roadway. We added a defense for game wardens for this very, very hypothetical scenario. You can see, I guess that was a problem. They're charging game wardens with shooting across roadways, so that they had to add a defense to it. So, I mean, you see, anytime a firearm gets discharged, guess what? There's probably some crime a prosecutor can concoct. So, keep yourself safe. Is it worth going to jail over? That's the kind of stuff I ask myself.
There's always a lot of intended and unintended consequences with these sorts of things.
Yeah, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And don't forget to leave your questions and comments in the section down below. Adding question to it helps out a lot. And until next time, we're the armed attorneys.